This video will explain what happens when you go to court. If it's hard for you to communicate with people who don't know you, you may need someone to help with communication. For example, if you use sign language, you may need a sign language interpreter. If you speak with or use a communication board or a device, you may want help from someone you know and trust. Sometimes the police and the court may want you to use a person called a communication intermediary. They will hire this person to help you communicate with them. This is because they want to be sure that communication between you and the police or the courts is correct and your exact words, not someone else's words. There will be many people in the courtroom when your trial starts. These people are the judge, the jury, if the accused chose a trial by judge and jury. A jury is a group of people who are chosen to listen to the information and decide if a person did or didn't do the crime. The court clerk, who makes sure everything runs well. For example, the court clerk hands out documents. The sheriff, who takes care of safety in the courtroom. Let the sheriff know if you're afraid of someone at the courthouse. The Crown Counsel lawyer. The defense lawyer, if there is one. The person accused of the crime. The victim of the crime, that's you, can be in court after you have given testimony when you've told the court what happened. Your victim services worker, if you have one. Members of the public, unless the judge decides to keep the public out of the courtroom. And your communication intermediary, sign language interpreter or support person, if you have one. When a crime has happened, the government prosecutes the person accused of doing the crime. This means that the government puts the person on trial. Usually, the police decide whether or not to charge a person, and the Crown Counsel decides whether a person should be charged with a crime and what the charge or charges will be. For example, someone could be charged with assault or robbery. It's the Crown Counsel's job to defend the law and speak for the community at the trial. This is why the Crown Counsel will prosecute a crime even if the victim doesn't want them to. The Crown Counsel is the lawyer for the community, not only for the person who has been a victim of a crime. Your victim services worker will let you know the date you need to go to court. The Crown Counsel will contact you for an interview before the trial starts. And this interview helps the Crown Counsel prepare the case and helps you get ready to be a witness at the trial. You can take a friend or an advocate with you. During the interview, the Crown Counsel might go over with you your statement to the police, ask you questions about the crime or attack to see if you're ready to be a witness, give you examples of the type of questions you might be asked in court. They can't tell you how to answer the questions. They might go over your victim impact statement if you made one, and they'll answer any other questions you might have. Canadian law says a person is innocent until they're proven guilty in court. You may be sure the accused committed the crime, but the court believes they're innocent until information and witnesses prove the person is guilty. The Crown Counsel must prove the accused person is guilty beyond a reasonable doubt. This means there is strong evidence, information given in court about the crime, that the person did the crime. After hearing the evidence, the judge or the jury will decide if a crime did happen and if the accused is guilty of that crime. The Crown Counsel will go first in the trial. Usually, this is what they'll do. Tell the court about the crime, call you as a witness and ask you questions about what happened, call other witnesses like the police officers who investigated the crime, friends or neighbors, or doctors or nurses who treated you at the hospital if you were hurt. Give evidence that helps the Crown's case, like photographs of injuries, medical records, or laboratory test results. The Crown Counsel's witnesses, including you, will also be questioned by the defense lawyer, and the judge can also ask questions. If you want to stay in the courtroom to hear other witnesses after you've testified or told your story, ask the Crown Counsel if you can stay. Sometimes this is allowed, and sometimes you need to go outside the courtroom. You'll often have to wait outside because you might be called back in to talk to the court again. After the Crown has finished talking about the crime, the defense lawyer gives their case for the accused. It's part of the defense lawyer's job to make sure all witnesses are telling the truth. They may follow the same steps as the Crown Counsel by giving evidence and questioning witnesses. Or the defense lawyer may not call any witnesses and say there's not enough evidence to prove that the accused did the crime. The accused person does not have to testify. The Crown and the judge can ask defense witnesses questions. After all the witnesses have given their information, the Crown Counsel and defense lawyer will make final statements about what has been said so far. If there's a jury, they will leave the courtroom to talk about the case. And when the jury has decided if the accused is guilty or not, they come back into the courtroom. If there's no jury, the judge can make a decision right away or make a decision days or even weeks later. The trial is then over. If the accused is found guilty, the judge will decide the sentence right away or at a later time. For example, if the person is found guilty, the sentence may be a fine or time in jail. If the accused is found not guilty, this doesn't mean the judge or the jury didn't believe you or that it was wrong to contact the police. It just means there is not enough evidence to prove it beyond a reasonable doubt. A not guilty decision does not mean the attack didn't happen or the trial was useless. Going through a trial tells the accused that an attack or an assault is a very serious crime. A trial gives you the chance to tell what happened to you and to tell the court and the accused how it hurt you. It can keep the accused or other people from doing it again.